Part 1. National Supervisory Authority in Europe. We are three geographical zones: European Union, European Economic Area, and Switzerland. In introduction of the chapter 1, the European Commission decided to harmonize the personal data protection regulation. Why? The idea is to permit a very large exchange in Europe for personal data, and for that we have to harmonize the situation on the base of the French law. Now, all the member states have implemented into their national law the Directive 95/46. The Directive 95/46 is based on three principles. The first principle is to protect the individual, the data subject. The second principle is to give special right to the data subject. That means the right to access, the right to modify, the right to avoid the process of specific computer use. And the third principle is to organize a protection based on a specific supervisory authorities. Supervisory authorities is an independent bodies, and the base on that is Article 28. We have now national super authorities in United Kingdom, Spain, Belgium, Luxembourg, and Germany. It's the same system like in France. UK. We have Information Commission's Office, ICO, with missions and powers. Three missions and powers: promote good practice and give information and advice, resolve complaints, and use legal sanction. It's a system very close to the French system. Spain, it's based on same general ideas, with missions and power like ensure compliance, consider the complaints for data subject, impose administrative sanctions and penalties, and issue authorization and draw reports. The main difference, like UK and France, is to impose administrative sanctions and penalties. We have the same thing in France because France is also a jurisdiction. Belgium. Belgium, we have an independent public body, the Privacy Commission, and missions and power are ensure the protection of privacy, the general principles, strike balance between the protection of liberties and the development of personal data processing, and issue deliberation, conduct investigation, review complaints, and act as mediator. Luxembourg. Luxembourg is a national commission for data protection with mission and power, control and check the legality of the processing of personal data, and take legal actions, issue deliberation, draft reports, and conduct investigation in order to control the situation and impose administrative sanctions and penalties. The National Commission for Data Protection is the same way that the national French data protection organizations. Germany, we have a Federal Commissioner for Data Protection and Freedom of Information. In Germany, we had a very legal framework in the same thing that the French framework in 1978. And for mission and powers, we have monitors the implementation of personal data laws and regulations, and keep a register like in France. Conduct investigation, issue recommendation, follow up and transfer complaints to competent authorities, and impose administrative sanctions and penalty. The Federal Commission for Data Protection and Freedom of Information is also, like in France, a jurisdiction. Adequacy decision. A Commission decision on the adequacy of the protection of personal data in third countries is based on Article 25 of the Directive 95/46. The adequacy test is a system to verify that we have a protection equivalent in other countries. The main idea, is to avoid to have data outside of European Union without protection. Iceland, Norway, and Liechtenstein have a system equivalent of the French system or the European system. See if I take Liechtenstein example, but it's the same for EEA, other countries. The missions and powers are monitor the compliance with laws and regulation and control processing. The European Commission compare the situation in Europe and the situation in that country, and the Commission decides that we have an adequate level of protection. And that way, it is possible to export personal data to that states. The last country is Switzerland. Switzerland have a special regulation with an independent public body, the Federal Data Protection and Information Commissioner. With that organization, we have also an adequate protection. That means that we have the same situation for protection in Switzerland and in the European Union. The missions and powers are supervised federal bodies, private bodies, and control the possibility to access data and to give recommendation, opinion, do a report, act as mediator. We have not a system of jurisdiction, but it's not necessary to have an equivalent protection between two states. Now, we talk 5 minutes about Schengen area. The Schengen area is a new system in order to organize the possibility to exchange special personal data. We have a Schengen information system for that exchange of personal data, and Switzerland entry in the Schengen system in 2008. Personal data protection officials. Member states may simplify notification formalities by creating a system, a very specific system, is DPOs, is personal data protection officials. That means for an organization, in order to avoid formalities, to designate a special member of the organization in order to support, to deploy, to assist the manager in the application of the culture of personal data. The personal data in that organization have a similar mission and power like the authorities without the power. The mission is to ensure their function in the organization with an independent matter and to keep the register of processing operation carried out by the controller. We have the DPO system in Germany and in France. In Germany, the German DPO is in the Article 4 of the Federal Data Protection Act. And for example, Missions and Power Act apply the data privacy law, understand the organization structures of the business concern, understand current IT application, be sensitive in relation to people, and resolve conflict. That means the culture of personal data, it's a very important element in order to apply in local situation the right of the individual, that example, the right to access, the right to modify, in order to take a very large protection of personal data. The French DPO, it's the same thing. It's in Article 22 of the French law. The appointment shall be notified to the CNIL. It process in independent form, And the missions is to keep a list of processing carried out. It's exercise effective oversight the own employer's data protection practice. It's an element of the culture of data protection.